Welcome back from break, those of you in the room and those of you online. We are going to continue now our HR Back to Basics session. We've entitled the next segment as HR Best Practices in a Cooling Economy. We, of course, don't know if that is coming at us, but there are some signs that it is. And I know I'm preaching to the choir, but our challenges don't go away, they just change when we are in a recession or a slowdown as opposed to a hot time with lots of hiring and the like. And so what we can say though is if it's not cooling now, it will cool eventually. And so a lot of what we have to talk about in the next segment may be useful in the next year. It will definitely be useful in the next 5 or 10. And it may be useful, we hope, whether or not we're in a hot time or a cool time. And so we just hope that this next segment is very practical, again, as I said, and useful. I'm joined for this segment by my partners. To my immediate right, Jillian Kornblatt here in Minneapolis. And on the screen, Aaron Goldstein from Seattle. Aaron, thank you for joining us remotely. And I'm going to turn it over to Aaron to start our segment with a nice little illustration of what may be coming. Aaron.
Thank you very much. So this is my contingent prediction of a coming apocalypse. And Ryan had a great lead in. We don't know if this wave is a few feet offshore or if it's miles and miles and miles offshore. And it's contingent because what happens next depends on the economy and the job market. As long as the economy and especially the job market stays really strong, this wave's going to stay offshore. But eventually the job market is going to cool and then this wave is going to crash. And it's also somewhat contingent depending on what's happened with your particular organization. If your organization has followed the fact pattern that I'm going to get into in the next several slides, then this wave really might be coming for you. Before I get into my entire discussion of performance management, I also want to make a really good point that I hope resonates with a lot of HR folks who are listening today. And that is, please, please, please don't think of performance management as just litigation prevention. That's my focus here today. But performance management can either foster or it can absolutely destroy employee engagement. You want your talent to be happy and stick around, and having good, effective performance management is a really key element of that. So as we go through all this, these are a few things that'll help you not get sued. They might help you with employment engagement as well, but I always want to remind people, performance management can really make or break employee engagement. So if we can go to the next slide here. So up until, well, currently, and over the last several months of this really raging job market, we've seen a really big drop off in single plaintiff employment litigation. And that's because with a really tight job market, rather than sue, someone can just go across the street. And in order to sue you for lost wages, someone has to try to mitigate their damages first. So right now in this hot job market, there's just not as much of an incentive to sue. And if someone does sue, it's harder to prove damages. So I'm going to walk through kind of how we got here and what's led to this. So if we go into the Wayback Machine here, and it does feel way back for me, think back to when the pandemic first hit. There was this global disruption. People were predicting kind of the end of the world here. Supply chain disruption. People didn't know when it was going to end. I actually did a local webinar here for a SHRM conference, and I remember talking to someone in kind of the local equivalent of the CDC, and we were talking about the presentation, and I said, I was going to use the analogy of London before the Blitz, but I don't want to be over dramatic. And I remember this person saying, "Oh, you're underselling it. That's not as bad as it's going to be." So everyone remembers companies went into crisis mode. Everyone went to remote work. Everyone started trying to figure out how it's going to work. We got tons of questions around here about, am I an essential business? Am I not? Do I have to lock down? Do I not? We had, toilet paper shortages. So everyone was just trying to keep the lights on and trying to survive. And so all performance management processes just stopped. You're going down the hall meeting with your manager all the way to regularly scheduled performance management sessions. They just stopped happening. And these serial crises got in the way of any attempts to implement new performance management systems. So we can go to the next slide here. And so, and this is kind of entertaining, the government actually starts paying companies not to fire people. If everyone can remember back to the PPP loans, the amount of loan forgiveness you got was tied to the number of employees you retained. So you were getting paid not to fire anybody. And especially in a world where no one knew what was coming, every dollar counted. And so any sort of performance management that was going to push people out the door, that just stopped. And then we had this very bizarre thing start to happen relative to at least what I expected was going to happen when COVID-19 first started. The job market actually tightened. And we had a situation where, whether you want to call it the great reshuffling or the great resignation, unemployment rates plummeted. And it was really hard for employers to find employees. And then you had people who had been saving a lot or not spending much during the initial parts of COVID lockdown, flush with cash, coming back into the economy, looking to spend it. And so there was a lot of demand. And so you've got this government aid plus, pent up demand, plus people, either reshuffling their job or sitting on the sidelines, led to a historically tight labor market. We can go to the next slide. And so employers became absolutely desperate for headcount. And so you had a situation where if you could fog a mirror, there was someone out there who wanted to hire you. And so, and we all had these experiences, right? Whether it was going to our favorite restaurant or whatever, places were understaffed and employers were terrified of losing whatever people they had. And so this led to a lot of performance grade inflation because a lot of managers had the calculus in their head. This person's not meeting what my expectations really are, but I'd rather have this person who's kind of bad than no person at all. And so you had either grade inflation or no ratings at all. And therefore you had no documentation or warnings, because if you gave someone a written warning, you might just prompt them to quit. And this created a set of circumstances that any employment lawyer that does defense side counseling over a period of time sees. You see this new low bar being set for poor performing employees, right? So you've got this consistent low performance that now is quote unquote meeting expectation or not being called out, which sets a new bar for what's acceptable. And as I started this section, the saving grace for employers was that the hot job market meant that employees were far less likely to sue. People could just go across the street to get a new job. And I even talked with some plaintiffs' attorneys who I am on good terms with, and they said, we're focusing a lot on wage and hour violations because people are just getting a new job going across the street. And if they do sue, they have an obligation to try to mitigate their damages. And when everyone's hiring and they're hiring at wages higher than you're probably getting paid right now, it's really hard to establish at least the most typical part of a wrongful termination claim, the lost wages. And so the big question is, what happens when this historically hot labor market cools? And that's that big wave offshore, because all of these poor performance management chickens are going to come home to roost. So if we go to the next slide here. So what should employees do? Well, what employees need to do is they need to start preparing now, because even if this wave of litigation is a couple of years offshore, fixing a broken performance management system takes time. I talked about grade inflation. You can't reset performance expectations overnight. And I think all of us who do employment advice and counseling have had those situations where a client calls and says, well, we want to fire this person and we want you to bless it and tell us it's going to be okay. And then you say, okay, great. Where's the performance documentation? And they say, well, their manager is really upset. So, okay, well, did the manager write anything down? No. When was the last review? Well, it's been a couple of years, right? So there's that scenario. Or even worse, is this person's a terrible performer. They're completely not what we're looking for. And you look at their last 6 performance management reviews, and they're all across the board meets expectations, right? And so that creates a giant problem. And you can't reset that bar by suddenly out of cycle giving someone a bad performance review 2 weeks before you want to fire them, right? So you want to, it takes a while to get these practices in place. So what I'm going to go through, this is back to basics, is remembering what good performance management looks like and how do you get there. And so one of the most important things you can have is good documentation. The way I get rid of potential single plaintiff wrongful termination suits on your behalf without you spending a lot of money on me is by taking all of the fantastic documentation you've put together over the last several months, arranging it in a very convincing way, and sending it to opposing counsel so I can convince an attorney who's paid on contingency that there's no pot of gold at the end of your rainbow. That if they sue you, they're going to end up with nothing. It's a waste of their time. And having that huge war chest of effective documentation allows me to do that. If I instead go to plaintiff's counsel and say, hi, my name's Aaron Goldstein, I'm a defense lawyer, your case sucks, just trust me, go away. It doesn't work very well. And so, I always tell clients winning a employment case at trial is losing, because you're going to spend hundreds of thousands of dollars getting there. Winning at summary judgment can also sometimes feel like losing, because you still had to pay for a bunch of depositions and briefing and all that. The win is when you convince the plaintiff's plaintiff's counsel to either go away or go away for next to nothing early on, because you've done all the stuff I'm going to talk about. So what does good performance management documentation look like? So what you want in good performance management documentation is a piece of paper that you can hand to a decision maker like a judge or to plaintiff's counsel that they can immediately understand, and that immediately communicates why this person ought to be fired or why they're not doing a good enough job. And so what you want to do is you want to stay away from things that sound subjective, like so-and-so's insubordinate, or so-and-so doesn't try hard enough. And you want to stick to very concrete examples of what you're talking about, the who, what, where, when, why details. And a great example of this is there was an employee who was about to be fired for having a messy office. And that could sound a little harsh, but through the performance management process, this particular client, over a period of a month, had walked into the employee's office and taken pictures of what the office looked like. And there was like flies buzzing around some rotten food over here. There was some papers marked highly confidential kind of splayed out on the floor. And so I didn't send the opposing counsel in that case a long letter explaining why they're going to lose. I sent the performance management documentation saying your messy office is unacceptable, and then I sent them the pictures, and we never heard from them again. That was just it. And so it's that type of thing you want to focus on. And so what does good performance management documentation look like? What does a good performance plan state? It states the rule, what's the thing that the expectation is, and it should be clear. How did the employee violate that expectation in a very clear, concrete way? What's the timetable for meeting the expectation, right? How much of a runway are you going to give this employee? And what are the consequences for not meeting the expectation? And you want to be really clear about that. I get the feeling a lot of the time that a lot of employers are kind of queasy about saying, if you do this again, you will be fired. But that is a very, very helpful final document. Like any kind of final written warning needs to say, if this happens again, you will be fired, right? Even the classic consequences up to and including termination aren't necessarily as good. And you also want to set a date for a timetable for following up. Because if you have a performance improvement plan and it's open-ended, and the person doesn't meet the expectations, but you never follow up and you don't terminate the person and months and months and months go by, you create a window for that employee to engage in some sort of protected activity, which then flips the case into a retaliation claim, right? So if you have an employee who is on a written performance improvement plan, they're not improving, and then all of a sudden, they figure it out, I don't know, they watch some Judge Judy or something, that they can engage in protected activity. 5 months after the performance improvement plan, they complain about something in the office like workplace safety, or just utter the words hostile work environment. All of a sudden, it's now a retaliation claim. So you want to set fair but tight timetables for following up. Can we go to the next slide?
Aaron, let me just add
sure.
one. Yeah, let me just add one thing to that. Lots of good advice there. What I would add is the old acronym KISS, right? Keep it simple, stupid.
Absolutely.
Avoid inside baseball. Make this, your audience isn't yourself. Your audience isn't the file. Your audience isn't even really, at the end of the day, maybe the employee. The audience, to Aaron's point, could be a lawyer, could be a judge. Worst case scenario, could be a jury. And so I've seen a number of what by other accounts would be really good, really thorough, nicely detailed, fact-specific performance management documents, but they're full of acronyms. They're full of industry usage that a third party just isn't going to understand and is going to muddy the whole thing up. And sometimes that's unavoidable. But really focus on your audience. Again, I was a little bit flipped by saying that the employee is not the audience. They are. But do keep in mind those third parties that are going to be reading this and how that can influence their understanding of just how bad the performance is.
Perfect.
And pictures of flies in the office.
In pictures of
Yeah,
flies.
yeah. No, it's
really good.
sensory details. Show, don't tell. Can we go to the next?
Send them the rotten sandwich. Just send
Yeah, there you
send
go.
the rotten sandwich.
So can we go to the next slide? Perfect. So no more grade inflation. And it's hard to fix this problem if you've had it. So a low meets expectations means not bad enough to fire. If you've got a 5-point scale and the second point, like a 2 out of 5 says improving, it's that sort of not quite where we want you, but we're working with you still. That means 2s across the board. You can't fire that person because there's going to be a presumption by a fact finder that, well, if it's 2 across the board and that doesn't sound like something you'd fire someone for based on the scale that you've come up with, it's got to be about something else. It's got to be about a protected class or protected activity. And as I'll mention later, there's no such thing as at-will employment anymore. Everybody is either in a protected class or has engaged in some sort of protected activity at some point. And so you can't fall back on at-will employment. You want to reinstitute regular performance management. There's a really good cliche that no one should be surprised by their review, and that's absolutely true. And so you want to see a buildup to the bad annual or the bad semi-annual review. There should be some written feedback going back and forth with the employee that tells the story about how you got there. When you get to the ones, how did you get to the ones? And quick word on employee engagement. Study after study shows that no feedback is even worse than harsh feedback when it comes to employee engagement. And so you're not doing any favors to employees by just not talking to them about how they're doing. And you want to have a plan for dealing with the misgraded, consistent poor performers. And there's a whole bunch of different ways to do that. If a new manager is being put into place, I call it the new sheriff in town play, where that person says, look, I understand that this is how things were going before. This is the new bar, right? And even if it's the same manager, that manager can do an expectation reset. Say, here's how things have been going to date. Here's the new bar. You're not being punished for how things have gone so far, but the bar is now being raised. Here's the runway you have to meet that bar, whether it's 6 months, whatever. And then you want to communicate clear and regular feedback and assistance to help that employee meet that bar. And I'll mention this in more detail later. You always want to communicate in writing that you are invested in your employee's success. If I were to sum up the style that you use for performance management to keep you from getting sued, it's we are trying to help you succeed and we want to see you succeed. If that comes off out of your performance management, a lot of missed details can be covered with just that impression, right? You're invested in your employee success. Get the details right. I'm not saying don't do that too, but stylistically, you want it to read consistently like you're invested in your employee success. Also, if you can, focus things that are within the employee's control. If you've got an employee who's failing to make sales, for example, you could say you need to raise your sales numbers, and that's a legitimate basis for saying that someone's not meeting their expectations. But even better, or if at least alongside that, you can say, we expect you to make X sales calls a day, because that's completely within the employee's control. And if they don't do it, they can't say, well, I was set up to fail, or it's harder to come up with excuses for things when it's all about, is the employee doing things that are completely under the employee's control. And so here we go with kind of my catchphrase here, Goldstein's law, don't be a jerk. It's like the single most important thing you can do as an employer to avoid getting sued. And what do I mean by don't be a jerk? It's at all times you want to avoid language that could be seen as mean or uncaring or unreasonable. I had a case that I worked on recently that I managed to settle for next to nothing. And one of the best facts was that my client sent the employee who was out on an ADA leave flowers twice. And so when plaintiff's counsel was saying, oh, you're mean, uncaring employer, and you were setting this person up to fail, I responded, well, my client's either Machiavelli and brilliant and setting up this whole devious plan to send your client flowers so they could put on this show of giving a darn, or they actually cared. I think a fact finder is not going to believe that they're trying to be that clever, months before they actually terminated this employee. And so your communication should demonstrate to a third party that your goal is to help the employee succeed. And I just came up with this idea, I think about 10 minutes before we started. I was furiously typing because it just popped into my head. Conduct your performance management like your most talented job applicants are watching. If you have a room full of people that are your potential hires, and you're pretending that those people are watching how you're interacting with the folks that you're performance managing, you will do it right, because you want to show a system that's fair, that's consistent, and that's effective. And if your system can pass that test, it's gonna sail way above the Goldstein's law, don't be a jerk bar. And so finally, I wanted to say another couple of words about employment, at-will employment being dead. It is. Everyone is either in some protected class or some form of protected activity. I'm now in my 40s, and so now I'm in a protected class. And so you always need a legitimate, non-discriminatory, non-retaliatory basis for a termination. You can't have a situation that we terminated this person just because when you say just because in our society today, it means a fishy reason. And the presumption by the fact finder is always going to be, well, either it was discriminatory, retaliatory, or it could have been, so you don't win summary judgment and you're going to trial and you're spending hundreds of thousands of dollars on your lawyer, which is something, while great for your defense counsel, is not great for your pocketbook. So I think that's the end of my presentation here. And Ryan, I don't know if you had any additional questions or thoughts.
With you, Aaron, I can't even begin. No, let's keep going. So Jillian, you're going to take us into the next section.
I am.
Aaron, thanks.
And so
Sure.
I assigned this topic to myself, and then I sat there to think, what am I going to talk about? And I was so overwhelmed. And I was really glad to hear Ryan say, there are so many things coming at employers these days. It's just so much. And some of it is contradictory, right? Like not everybody needs the same thing. And we hear a lot of talk about, the office is dead, workers want flexibility, remote work. At the same time, though, there are many, many employees who are the opposite. They don't want flexibility, they need predictability. And so that is a really important thing in scheduling. It's often part-time workers. Employee health and well-being, we'll go into that. I'm sure you've all seen the headlines, people's mental health is terrible in general. Adults, teenagers is even worse. So that's likely impacting a number of your employees. Compensation, we've got, historic inflation levels, along with this fight for talent, driving up salaries. And then there's pay equity concerns, which haven't gone away. They have actually increased, and I'll talk a little bit about some of the laws covering this. And then I just wanted to touch on the trend toward unionization, because I think part of that captures all these things going on, right? Everybody is dissatisfied in some way with some aspect of their work life, it seems. So I think that's a part of this trend that is definitely happening. So employee scheduling laws. So these are not in that many locations yet, but they are catching on. Some are state laws, some are city laws. As we're talking about this flexibility rising for office workers, these frontline workers, and these penalties are, sometimes they seem small, $50 a week per employee in New York City, but that added up to a $20 million settlement for Chipotle because things had been going on so long and there are a lot of employees. So just wanted to mention these. If, unions are something you do not have and you do not wish to have for your workforce, I think doing some of these things proactively that we're talking about is a great way to head that off, because people who are already happy with their working conditions are not generally electing unions these days.
Jillian, before you go on to the next topic, I'm going to do this just because I haven't been able to do it for 3 years. Who remembers, by show of hands, when predictive scheduling was a proposal in Minneapolis and St. Paul 6 or 7 years ago? A few, yeah. You remember because it was horrible, right? It was so bad that the employer community rallied together in a way that had never been seen before and really hasn't been seen since in opposition to that. So we don't have anything, proposed in Minnesota right now for those of you who are in Minnesota, but the whispers are there. There's still people talking about that. So you'll remember things like how agricultural related businesses were supposed to have exact start times and no unpredictability with the weather. It was just crazy. And so this is something that is worth keeping your eye on, and we'll keep you informed as this might come back, but it's not dead yet, even in Minnesota. And if it were to come back, it would be really bad. Thank you for indulging me with the hands.
Sure, yeah. So, and then of course, being 2022, we have predictive scheduling law bans. So these states have enacted laws saying that municipalities can't regulate employee schedules, or that they just can't enact any municipal employment laws at all. So just wanted to put those on people's radar. Employee health and well-being, we could do a full hour on this very easily, but just wanted to hit on some key themes that we're seeing. Employee isolation, I know that falls into HR's lap a lot of times to help deal with that. There was an interesting article in the New York Times lately about how these unprecedented and confluence of work conditions have led companies to start positions with these really long and weird titles. One of them was somebody had a chief heart officer, and their job was to focus on decreasing employee loneliness and increasing employee connections. So that's part of it. So I'm a recovering HR professional, but now sitting here in my lawyer hat, I have to say, when those kinds of things are great. Be careful of protecting employee medical information. That requirement is still there. So think that through, not dissuading employers from having these kinds of efforts, because I think it's very both healthy and good at employee retention as well. Keep in mind that employee health can impact performance. That is one thing that is particularly hard when you're dealing with employee mental health issues, because often the symptoms directly go to performance. And so that's a really tricky thing to handle. We've heard a lot about disability accommodations a little bit. Jack's got the legal phrase, engage in the interactive process. I'm glad I didn't use that on the slide. But a couple of things that I think we didn't quite touch on, but remember, one size doesn't fit all in reasonable accommodations. So it is a sliding scale based on the organization's size, resources, number of employees. So you do not have to feel obligated if you're a small employer to do the same things a giant employer would. Annabelle earlier talked about the trial period for work at home. That's a good example. That was, in the idea of seeing if work at home could work. I advise clients, it's also a good way to see if an employee can perform. So if an employee is having performance issues, they want an accommodation, maybe the manager doesn't want to give it, not really strong reasons. My advice is give the accommodation, be generous, do what you can to help the employee. If it works, fabulous. If it doesn't work, you've done everything and now the employee is still not performing. It makes a much cleaner termination. And then after effects going on with that. So, and finally, it's so important to have a good process that employees know about. They have to know who to go to in your policy and add in there, nobody else is sufficient, because I've had situations where employees are saying, oh, my employer knew about this disability, but they hadn't told the right person, so they didn't actually know. So is the pandemic over? We heard about this earlier, so I won't go into a lot of details here. One thing that has been coming up that I've been hearing is employees have concerns with relaxed prevention measures. And it's often in the context of they live with a family member who is at high risk for COVID. And this has been a tricky issue all through the pandemic because the ADA does not require accommodations for somebody's significant family member outside the person. But it is an important role. It's a tough issue, and just, keep that in mind. And, again, here, if there's a way to do it to help the employee stay, it's good employee retention. It's good in a lot of ways. And I put monkeypox on there. I hate seeing that. I saw it today. I was like, oh, that feels terrible, but we don't know what might happen. But the good news is, you all have a blueprint of what worked and didn't work for your company. So it's a good time to think that through and, think about next time what we would, maybe want to do differently or the same. And then we come to pay equity, which is a huge issue. It is still happening. In 2021, the US Census found that the discrepancy between women of color and white non-Hispanic males in pay is tremendous. I believe it's 63% and 55% as much for Black and Hispanic women. So it's a present issue. And so there's been different laws enacted to try and address this in different ways. So one of them is salary transparency, and that is laws that require employers to basically tell everybody what they're going to pay for the position up front. And it can be, you have to put it in your advertisements, you have to let your employees know. Some of these laws apply only to certain industries, some are widespread. There aren't a ton of them right now, but this is another area that I think we could see a lot of growth in. And these are hard. Employers tend not to like them. They don't want their competitors to know what they're paying. They don't want all these things put out there. So think it through, make sure that you've got your compensation system ducks in a row, because if it is going to become public, you have the attraction of the employees, you have the competitive issues, but also how are your current employees going to react? We often hear that current employees are angry because people coming in from the outside are paid more, which is a phenomenon. So something to think through. I don't know if anyone has mentioned our blog today. It's called Quirky Questions. And Brianna Altakatika, who's going to talk next, has a great one on the Colorado salary transparency law on there. So, and there's also some good back to basics posts on other topics as well. So these are ones where this is a different type of law, applicant salary history bans. So these are where employers can't ask about employer salary history. Again, these vary in what they require. Some are just, you can't ask, some have anti-retaliation provisions. But again, this list is growing, so it's something to be aware of. And they apply to your current employees. So think about that as you're going through promotions. They come up in mergers and acquisitions, right? Because now you know what everybody was paid at their last job. So those are places. And I realize I'm going pretty quickly, but I wanted to touch on the different aspects of this here.
Yeah, these are important things.
So we have now another angle. This is wage disclosure protection. So these states have laws saying that employers cannot tell employees that they can't discuss their wages. As an aside, under the National Labor Relations Act, you have to let employees talk about all sorts of things like that. Remember, that law applies whether or not your employees are unionized. So Minnesota has one of these that's had it for a long time, or fairly long time. I don't know. I have no sense of time these days, to be honest, but it's been around. But it's got these same requirements. Can't tell employees they can't discuss their ways, can't retaliate against them for doing so. And now we come to another angle on the pay equity lens, and this is the actual pay equity study, which is, it's a big deal, but it's a really good thing to do if your company is up for it. So the EEOC collected all this pay data in 2017, 2018, got continued to 2020. And I will only mention that the EEOC had a recent news release about this study that was done. I still can't figure out why the National Academies of Sciences, Engineering, and Medicine were looking at EEOC data gathering effectiveness, but they did. And what they found there's some value in it. They also found that some things need to change. But because of that study and the EEOC posting it as a news release, it tells me this may be something they're interested in going forward. The company pay scale does these surveys of employers that are going to conduct pay equity studies in the next year, either gender or race or both. Usually it's both. And this year, 52% of employers said they were going to do these. So over half. This is something employees are demanding often. They want pay equity. This can also come from outside shareholders, a lot of sources. We can do and have done a whole session on pay equity studies and how to do them in best practices. So I've included a few of those steps here. This is not comprehensive. The first one, though, I think is so critical. You have to have leadership buy-in before you start one of these, because in many ways, your worst scenario is that you do a pay equity study, you find out there's a problem, and then you do exactly nothing because the company doesn't want to put any money into fixing it. And if there is a problem, putting money into it is the only way to fix it. You can't reduce people's salaries to get them even. So you have to bring them up. So it's important to do that at the beginning. That said, do it under attorney-client privilege so that, this is not going to be public to the best you can, and think it through. The last thing I'll just mention at the end of the list, think about not just are people in the same job being paid the same, but also are people being placed in similar jobs? That's called a steering claim. And there have been ones against some tech companies a couple of years ago that male engineers were steered toward certain jobs, female engineers were steered toward other jobs that were less prestigious in the company. And then last, putting it all together, unionization. So filings have increased for unions 58% during the first 3 quarters of 2021. These are going up. Recently, the Trader Joe's in Minneapolis voted to unionize. For all you Trader Joe's fans, that's new. They do not have unions. So that's seen as a bellwether. And so unfair labor practice charges are also increasing. And keep in mind, again, that can happen even if you don't have unions. So something to keep on the radar. And that is my fast spin through some hard issues, but just wanted to put them on your radar.
All right, thanks, Jillian. And just to reiterate the last point that she made, if you want a terrible forum to be in the context of a dispute, it's the NLRB. And so really do pay attention to these labor issues. Jillian's exactly right that they apply to union and non-union workplaces. And that organization, that entity, the NLRB, is so unfavorable to employers right now. So you just really be cautious about that. So, all right, I have to talk about terminations, and I have to do it in 11 minutes, or that practice group leader guy is going to pull me off the stage. So I have a high risk of saying both too much and not enough all at the same time. So what I'm going to try to do is go back to my early kind of introductory comment this morning, and that is I'm really going to try to make this practical, share with you some observations that have occurred to me over the last couple of years of counseling employers through termination situations, some of them tricky, some of them not. And what I've done is I've prepared 3 rules for effective terminations, because it was that or 3,000, and 3 sounded easier. The first one, and this is only partially tongue in cheek, follow Aaron's advice. That performance management issue, bringing that current and making sure that you have really effective documentation. So very fact-based documentation, objective expectations, not something that's kind of wishy-washy or subjective if it can be avoided. Clear timetables for performance. And again, as Aaron said, really critically, demonstrating the company's support and encouragement of the employees. That yes, we have a tense moment here in terms of the employees' underperformance, but really demonstrating that it's the company's wish and desire to support and help that employee succeed. And then to wrap it all up, clearly communicating all of the above is really important. If I could ask all of you out there, all of the clients, all of the non-clients, all of the employers across the board, if there's one thing that you can do in anticipation of terminating somebody, whether that's tomorrow, whether that's next week, whether that's 2 years from now, really double down on the performance management issues and recommendations that Aaron gave you a little while ago. And that has both practical and legal benefits. It's going to make the termination meeting not necessarily happy, not necessarily smooth, but a whole lot easier if you've got objective, clear things that you have pointed out, that you've set expectations of, and you can say, listen, this is what we asked, this is the timetable, these are the resources we gave you, and you didn't do it. It's hard to argue about that for the employee in the moment. And again, it has litigation benefits if we're in a wrongful termination scenario. Allows Aaron to send that letter to the other side saying, we gave perfectly clear notice about what was expected, and it just wasn't satisfied. So really, really important. Rule number 2, which I've described as play devil's advocate. You all are in your jobs, whether that's employment counsel or HR, because you like to have difficult conversations. And sometimes that's with your own management. And that's the gist of this rule. You've got to do some analysis. Look at the protected classes and compare to others outside. Make sure you understand the protected complaints that might be out there. But here's the first place that I can talk to you about management. You might have to do some investigation and education, because your managers may not have told you about that complaint, or they might not even recognize it. You know, a lot of people kind of think of complaint as a lawsuit or the EEOC. It's not. You all know that. But the managers often don't. They could have an email gripe that used some magic language. They could have a verbal conversation where the employee said, I feel like this is a hostile work environment. Lots of different ways it can come up, but your managers might not recognize that. So make sure you as in-house counsel or the HR professional understand what protected complaints are out there. And then consider your worst case scenarios and think about your evidence. And again, this goes back to Aaron's comments about having those documents all lined up. How are you going to prove the fact that you have a legitimate business reason for termination in a world where Aaron's right? Nobody likes to hear it, but he's really right that at-will employment isn't officially dead, but it's impractical. Nobody can rely on it. And again, you might need to have some hard conversations with your management groups about this. And that's a really effective question. I believe you, but how are we going to prove it? Show me the documents. Who witnessed this? That's a really effective tool for you to press in an appropriate way to make sure that the risk is manageable when you're talking about these terminations. Another thing that I found to be really helpful in counseling clients and then clients counseling managers is just a recognition. And again, this is something where you're going to have to stiffen your spine and have some hard conversations that, yes, managers, they're wound up. They themselves are emotional. They probably have really good reasons to be in that state, given the frustration that they've had with the employee's non-performance. But you've always got to think about the terminations through the lens of a third party, whether it's the lawyer that Aaron talked about, the judge, the juror. Juries, judges, certainly opposing counsel, they think employers can move mountains, that they should really give every non-performing employer 5 different opportunities to succeed. So when your managers are gung-ho to fire, you've really got to pause and think about, again, what our evidence is, how we can persuade the others, and keep in mind that the others' expectations will be a whole lot more, a much higher bar than your managers. And then consider a separation agreement if you don't have a solid justification that you can prove. Doesn't have to go that way, but it is an option, and it's one that experience suggests is going to be less expensive, less burdensome, less annoying, less emotional heartache, 99 times out of 100 compared to actual litigation. Of course, you've got to do some risk analysis and discounting for the likelihood of the suit and all. But if you don't have the basis to make that argument for a legitimate business reason, you got to think about that exit. You may not have to pay a fortune, but it's got to be on the table.
Paying
right.
for peace.
And for peace. Then think about timing. And I've put a lot of things under this. Avoid tipping your hand. We all know this, but it's really been driven home to me over the last couple of years in multiple respects. An employee can be a poor performer, but they know what's coming, right? So if you set a meeting that doesn't have a specific topic for next Monday, and they know they've been a poor performer, they probably know what's coming. And you've given them an opportunity to do something like raise a complaint, ask for leave, tell HR that somebody is discriminating, blow the whistle on something that may or may not be legitimate. So be careful. And that's not to say that you haven't had all of that very clear performance management. If that's the scenario, it could be a behavioral issue that's a little bit different. But really think about not tipping your hand and giving the employee an opportunity to create trouble. Very closely related to this, and this is big, make a record of when the termination decision was made. So if you have decided to terminate an employee, but that meeting is not going to be until next Monday, at least send an email or have the manager or the executive send an email to you saying, yeah, we're going to meet with Bob on Monday to separate his employment. So that if the employee does something like raises a complaint, blows the whistle, asks for FMLA leave, whatever it is, you've got the record that your termination decision predated that protected conduct, which really is important in that if you want to pull the trigger on that termination. We've talked at different times, and I've had conversations with a lot of you about the timing of the termination meeting. Some of that's real easy. Don't do it on Christmas Eve. But I mention it here because that's become a bigger part and a more expansive issue in a lot of discussions that I've had. And just by way of example, a couple of months ago, I had a really good faith, serious conversation with an employer who was about to terminate an African-American employee the day before Juneteenth. And there was serious conversation about whether that was the right time for that particular employee, given that the employer had reason to believe that that was a very important day for that employee. And so just be mindful that it's not just Christmas Eve and Thanksgiving and New Year's, but it could be individual to the person. If you know the birthday, don't fire them on their birthday. It could be any number of things, but do think about the timing of that. And that's all under the header of making sure that the termination meeting is conducted in a respectful manner. Talked a lot of times over the years, don't march somebody out with the cardboard box in front of all their peers. Allow them to leave with dignity, their head held high, because that can cause the termination to go sideways just as much as the underlying reasons for it. And then just a note, do pay attention to your final pay requirements and state laws, because if you've got people in California in particular, that's really important. All right, I've got a minute to do a bunch of things. And so what I'm going to do is I'm going to take this clicker so I can move quickly. The next one, Trevor talked about this in the last session, but it's worth mentioning here just to remind you to be planful. I see a lot of employers who are really good about thinking about how they're going to cut off access the day before. But think about how you're going to protect your confidential information, your trade secrets well in advance. And that's kind of systemic. That's to your employee group as a whole, because if you got somebody who's going to walk out the door with confidential information or without the restrictive covenant that you really wish you would have had, figuring all that out the day before termination is not going to work. Actually, what I'm going to do is I'm going to focus on this and we'll rest on the slides for some of the other things. Really think carefully and be thoughtful about providing instructions on this stuff. And Trevor didn't quite get to this point, so let me hit it. When you have an employee who's leaving, be really clear in your meeting and in following up in writing, stating what you expect to happen, that they have to return certain property, that they can't just wipe their computer. You might want stuff back, or at a minimum, you want to know what they had. That they have to provide the information about access and the like. you can send them the box, you can give them the website to return things, but be really clear about that and follow up in writing. That not only has practical benefits, but I will tell you that just the last couple of months, I've had a couple of cases where it was really important that we could show that the employee who then proceeded to spoliate documents, wipe their cell phone, kept things that they didn't share with us for a long time. That was bad faith on their part because the employer was so crystal clear. So just as you're looking for nuggets to take from this, if you have to terminate somebody, really be careful about giving explicit instructions in terms of what you expect to have back, what you expect them to do with electronic data in your devices. A severance plan, one sentence. There's a lot of difference out there among employers about the wisdom of a severance plan, but it's worth some thought, particularly if we're facing the wave of terminations or the wave of litigation that Aaron talked about. There's a benefit of simplicity. There's a benefit of setting expectations. There's a benefit of limiting one-on-one negotiations if you have to terminate a large group of people. ERISA benefits a whole lot of things. So again, I'm not here to say that you should do it, that you shouldn't. People have strong views on this, but it is worth some thought. And then just again, very briefly, a lot of you went through this with us at the beginning of the pandemic, but do be mindful of running the traps when it comes to group terminations. Think about disparate impact. You do it early and you do it often. Early in the sense of it, if nothing else, run a back of the napkin calculation on the people who are going to be affected and those who are not. So that if you have a glaring error, you can call us and we can help you do a much more fulsome and correct analysis of disparate impact, and do it often, because as you all know, the plan, when it comes to those reductions in force, changes every 5 minutes. And so make sure that you didn't just run the analysis on plan A and your company affects plan G and you've lost the value of that disparate impact analysis. Remember your Older Workers Benefits Protection Act requirements when it comes to those releases. Remember the WARN Act. And the only thing I have time to say on this is that it is extremely complicated. It requires a ton of forethought. We're talking about 2 months minimum notice, and you've got to think about that even before that to do it right, because there's a lot of landmines. You've got to prepare notices, not just to the employees, but often to the union, to government. It's really important to think about that way ahead of time to the extent possible. There are some exceptions, but tongue firmly planted in cheek only partially. They don't apply to you. Don't assume that you can get away with not giving warn. Those exceptions are very limited, so you're going to have to run those traps, and beware of your state WARN acts as well. With that, we are out of time. Again, before you go on our break, and this one's going to be about 7 minutes as well, do make sure that you are signing up and returning those attendance forms either online or here so that we get you the credit that you are due. So 7 minutes, and we will be back for our final session. Thank you.